Hello everyone, welcome to another session of Lucid Mails. Today, we will be discussing about the recent government order that permits agencies to access information stored in computers. Now, this topic can be asked in your GS2 or GS3 paper. Also, for those attending interview this time, this topic is crucial because it is a heated discussion at the national level. So, first of all, let us look into the recent notification. In the third week of December, the Cyber and Information Security Division or CISD of the Union Home Ministry issued the notification. It authorizes 10 central agencies to intercept, monitor and decrypt any information generated, transmitted, received or stored in any computer in the country. This notification is based on Section 69(1) of the IT Act of 2009. Now we will look into the provisions of Section 69 detailed in the coming slides. So, as per the notification, the authorized agencies include the Intelligence Bureau, the CBI, National Investigation Agency, RAW, Enforcement Directorate, Central Board of Direct Taxes, etc. It also specifies a 7-year imprisonment and fine for non-compliance with the authorities. Now, let us look into the legal provisions that permit the government to issue such a notification. The basic foundation for all such notifications are based on Article 19(2) of the Constitution, which provides for reasonable restrictions. Now, for this notification, Section 69 of the IT Act is used. This section was introduced through an amendment to the IT Act in 2009. Section 69 gives the authorities the power to intercept, monitor or decrypt any information through any computer resource. The IT rules of 2009 provides the procedures and safeguards for such interceptions. As per its Rule 4, only a competent authority can authorize such an action. This competent authority is the Union Home Secretary or in case of states, the State Home Secretary. Now, let us see the arguments that support the government's move. Now, prior to this notification, back in 2009, the then UPA government also issued a similar notification. The present notification is supposed to bring about more clarity to the 2009 notification. The present notification defines the permission of snooping. Another supporting argument is that the process will continue to require prior approval from the Home Secretaries. Also, the present notification do not grant any new powers to the 10 mentioned agencies. Thus, the chances of arbitrary use is limited. Add to this is the fact that the IT Act itself has robust review mechanisms in it. Thus, the Ministry of Home Affairs has repeatedly reaffirmed that the notification in no way promotes snooping or mass surveillance. But despite these supporting arguments, there are still many concerns that have risen following this notification. The first and the most crucial one is the fear of government-sponsored mass surveillance. Another concern is that the notification is silent on the procedures part. It does not mention any procedures that the agencies need to follow while undertaking any interception activities. Now, as per the existing architecture, the agencies need to notify the Home Secretary in 3 days. If no approval is given within the next 7 days, the interception needs to stop. So, basically, the agencies have 10 days of blanket license to snoop. This clearly goes against the individual's right to privacy. As we already know, following the Supreme Court verdict in the Puttaswamy case, the right to privacy forms a part of the fundamental rights. Hence, such a notification does come in conflict with the Supreme Court verdict. The lack of judicial oversight in the present procedures further adds to this conflict. Another cause of concern is our rising push for data localization. B.N. Sri Krishna Committee on Data Privacy also suggested that India needs to increase its data localization. But with increase in the volume of data, the scope of interception also increases. Another serious issue is the poor history of our intelligence agencies. Most of these agencies are barely accountable to the Parliament. Also, agencies, for instance the CBI, are often criticized for being mere puppets in the hands of the ruling government. There is also the issue of misuse of arbitrary powers by the agencies. Since its inceptions, encounter killing has been a highly criticized issue. So, giving more powers to such agencies such as the police, especially those that deal with individual liberty, could prove to be disastrous. Another concern is the is that global examples have not been promising. Take for instance the PRISM program of USA that Edward Snowden revealed. Now, we cannot assure that such a scenario will not arise in India. So, it makes the notification a very legitimate concern. Another concern is the misuse of such provisions by the ruling government. Many times, agencies like the Film Certification Board have been accused of being used as a tool for the government to silence its oppositions. So, if the government is given arbitrary power in the cyberspace as well, it can invite severe violation of the right to speech and expression. Last, and another significant concern is that the order was issued without any wide consultation with the concerned parties. Now, let us look into what needs to be done to rectify these concerns. The first major measure should be the creation of a data protection regime. This can be in the lines of European Union's General Data Protection Regime or GDPR. While framing such a law, three factors needs to be kept in mind. First, a law that allows encroachment. Second of all, a reason that should sound legitimate. And third, proportionality to the need. The regime should also lay down the procedures for encroachment as well as penalties for violations. Besides this, the judiciary must be made an active part of the system. Court orders must be made mandatory for all cases of interception. Also, the approval committees should have judicial members in them to prevent arbitrary use of the government agencies. Besides this step, the accountability of our agencies needs to be ensured. For this, multiple lines of accountability should be brought forth. This should consist of executive, judiciary as well as the parliament's actions. There should also be a strong framework and well laid down procedures put in place to ensure that the encroachments is justifiable. Last but an important measure should be an overhaul of our IT Act of 2000. Since right to privacy is now a fundamental right, changes needs to be made in this act. These measures are vital such that a balance is attained between an individual's liberty and national security.